So I wanted to do the jails first. So let's see here. Who's in jail? We got Hertzler.
Hertzler.
And then 2 o'clock. So. Okay, what's that?
Hertzler.
Hertzler.
Okay.
And are you Christopher Hertzler appearing from the jail? All right, and let's see. You're Mr. Uzalita? Is that how you pronounce that? Poinzalita, okay. All right. This is case number 21 CR 165, State of Ohio versus Christopher R. Hertzler. This hearing is being conducted by Zoom. Mr. Hertzler is appearing by from the jail. His counsel is appearing by Zoom from his office. There's a prosecutor, Ms. Collins, is appearing from her office. This case is set for trial on December 15th. I believe Ms. Hackner was appointed as counsel for Mr. Hertzler, and Mr. Slyman and Mr. Gonzalita entered their appearances yesterday and filed some motions, one of which is a bond reduction. So at this time, Mr. Gonzalita, you can address that motion.
Thank you, Your Honor. Yes, that's correct. We have filed a motion for a bond reduction. We respectfully submit that Mr. Hertzler is a candidate for OR bond reduction due to the following. He will show that he honesty is not a public safety concern. He does have a lack of criminal history other than these pending allegations. He lives in Hillsborough at 705 Street, Pleas. He will be living at that address. He has been living there for about 4 years now. He is on the lease with his wife of 17 years of there. He does have gainful employment and Hunter's Edge processing. We're ready for active come in to be able to get that to work, but he does have there is so he can continue to contribute economically to standing. In addition to his wife, he does have 4 children, ages 16, 15, 13, and 12. They all work for school there in Hillsborough. He is previously born in Texas, as I mentioned, he was in the state of Ohio for 4 years. No criminal history to speak of, so he does not go to public concerns. We do ask for that's what we ask.
All right, Mrs. Collins, on behalf of the state.
I didn't realize Mr. Lita did not serve up any of this, but I didn't realize that he was even an attorney. Mr. Hertzler actually does have an assault which caused bodily injury to family, which he absconded from in 2017 from Texas. I would also point out that the children that Mr. Lita named are actually the children that we allege were the juveniles present in these drug buys. So if he were to post bond or lay bond, the children that he is talking about living with are the children that were present during these drug buys.
So the assault, I know you listed it on the discovery compliance. It shows that he's wanted in Texas for that. It's a misdemeanor.
It doesn't have like an active warrant, it just shows that he's absconded.
Okay,
Maybe from probation or something like that.
all right. Okay, anything else, Mr. Ponzillo?
No, Your Honor, we just asked that if any, reduction bond can be made, we will take that, just so as, the prosecution did when we were just recently detained, we're trying to get this, case under control and, under our direction. Mr. Slayton would have been present, but he's still a magistrate at this time, and so, we just repeat what he asked for prior.
All right, well, with regard to, the motion, now, you do have concerns about, the, situation in Texas, since that, he's lived here for 4 years, which corresponds apparently with the timing of that case, which would, lead one to infer that, he left to get away from that, and then therefore it's concern the court has that he might leave this state to, avoid, this case. So, I'm going to reduce the bond to $10,000 plus OR plus all of the other conditions in that entry, and additionally that he not leave the state of Ohio during the pendency of this action. And so, if you do make that bond, Mr. Hertzler, you have to report to probation immediately and then obey the conditions that are set in that order.
Remember that the 10% extra?
No, it's $10,000 bond. No 10%. Now, Ms. Collins, did you receive any of the motions that they filed yesterday, or I guess it was on Monday?
No.
All right. You need to serve those, Mr. Poinzella. It says you did, but it says you didn't get them. But I will also tell you that two things I'm going to go ahead and address right now. First of all, you filed a motion for discovery. That's summarily denied because there's been discovery provided in previous counsel, and just because you're new doesn't mean you get to start everything over from scratch. You need to contact the attorney, get her file, and then look at it. If there's anything supplemental that you want to ask for, then you can do so. But they have complied with discovery, so motion for discovery is out of order. And then you asked for a motion to properly preserve catalog all physical evidence, and it asked the court to take action. And I don't grant those motions. This is an issue of Brady and due process. If the state does something, it's actually your advantage if they did. Because if they destroy something that shouldn't, then that would be in your client's favor. But I'm not in the practice of entering in and ordering the state sheriff to do something. They have responsibilities to that, and if they should violate that, then it will fall back on them. So I'm not a big fan of these kinds of motions. So those will be denied. All right, now you also have asked for a motion to continue. Have you discussed with your client the fact that this would waive his speedy trial time? All right, Mr. Hertzler, under the law, you have a right to be tried within 270 days of your arrest. However, if you've been held in custody as to a pending charge only, then every day that you were held in custody counts 3 for 1. And so I assume you must have been arrested sometime in September. It looks like September the 20th. And so right now your speedy trial date would be around December 20th or so, 20 or 21. I believe we have a trial date set for December 15th. Now, and if you want to have your attorneys have more time to prepare for this case and have a continuance, since it's just a little over a month away, I'm willing to grant that. However, if in order to do that, you have to be amenable to that or agree to that, and agree that you'll waive their speedy trial time. And so that would, that'll push the case into January probably. Are you in agreement with that? Okay, so you're agreeing that the court should grant this continuance, and you're agreeing to waive your speedy trial time due to that continuance. All right. Okay. You have a trial calendar there, Mr. Winslow, about, January 27th.
And Thursday, yes, that works.
2 days be enough to try this thing, Ms. Collins?
I'm not sure, Your Honor, probably, but,
Well,
they are currently scheduled to be tried together, they're tied together, so that it's scheduled to be tried together.
well, you know, I haven't addressed that issue yet, I don't know if they can be or not. When is the
Right
defendant
now,
scheduled?
they can be.
When is it,
And
when is the defendant scheduled, co-defendant scheduled?
he's scheduled for the 13th of December.
Okay,
They are scheduled together.
okay. Well, I'm gonna continue this case. If the other defendant wants to continue the case, you know, I guess we can do that. But, you know, that case isn't in front of me, so I can't do anything about that. If you wanna ask for a continuance, then, and a motion to join the trial, and I'll certainly entertain that, we may do that, depending on, if the law permits.
Well,
So, pardon?
I was just gonna say the law does permit, that's why we united together.
Well, again, you know, there are two sides of the story, I'd have to hear the other side first before I rule that. What I'm saying is, if the law permits it, you want to ask for continuance, I'll entertain that, if the law permits it, then I'm probably granted. So, anyway, based on that, then I don't think I want to look at January 27th, how about January 24th instead, that's a Monday. That gives us a safety valve.
That works.
All right,
Um,
so we'll set the trial for January, pardon me?
I have a second one over.
Yeah, I can put you in the breakout room, you want to talk, Mike? Okay.
Thank you, Your Honor. I have a question.
Okay?
The previous
Oh,
one.
wait a minute, I gotta close out Greg, I wrote so we had to find back. All right, there it is, all right, go ahead.
Your Honor, the previous one that said 50,000, that was a 10% tax sharing.
Well, I don't know who said that, but, I don't think I did, because I don't set 10% bonds. I'm not aware that that occurred. Let me look at my arraignment entry. No, $50,000 cash, real estate or surety plus OR, no 10%. I was gonna say, I've never set a 10% bond.
Okay, that was okay. Because, you know, we had numbers of like next one.
Right. Now, as far as the trial date is concerned, that's gonna be the tentative trial date, subject to the ruling of the court on the joint trial. We have a suppression hearing on the other case set for next week, and so, we'll bring Mr. Rapp up, so Mrs. Collins, if you are going to try them together, suggest you get that file as quickly as possible. Well, actually, you don't have to, because you joined them, so it would actually require a severance, so. So what I'll tell Mr. Rapp is that I'm going to go ahead and continue it unless he wants to sever. But in the event that the defendant, co-defendant is not available on that day, this extension or time waiver will go to whatever the next available date is with both attorneys and both defendants are available. So I just wanted to clarify that, Mr. Onzelita and Mr. Hertzler. You understand, Mr. Hertzler? All right. Okay. So, looking at December 15th, you available then? All right, we'll make that at 2:30, and that'll be a Zoom. So if your client is able to make bond, he'll need to be available by Zoom. He'll need to get us either be at your office or get us a separate email where he will be able to participate. All right, anything, and also, under the local practice, any pretrial motions are due by the final pretrial. So, that we can have this, determined well in advance of the trial date. And your responsive discovery will also be due by that day. All right, anything further from, council?
I'm not gonna.
Ms. Collins? All right, she's muted, but she nodded her head no. All right, thank you.
Nothing further.
Okay. All right, thank you. All right. Now, what was it? Oh, I didn't change that clock. It said 2:30, about that. All right. Okay. Okay, Kayla Valentine. Ms. Valentine, if you would unmute your mic and also, activate your video, please. Oh, yes, I'm sorry, go ahead, you log off anytime, thank you.
Okay, thank you.
All right, we have two cases here involving the same defendant, case number 20 CR 126 and 20 CR 226. Both State of Ohio versus Kayla Sue Valentine. Your Kayla Sue Valentine there in the box that has Kayla Valentine in the corner.
Yes.
All right. This hearing is being conducted by Zoom. Ms. Valentine is occurring from her residence, I assume. Her attorney is Daniel Witt. She's occurring from her office. And appearing from for the state is prosecuting attorney Thomas. Now, in case number 20 CR 226, the defendant is charged with failure to appear. And 20 CR 126, she is charged with possession of heroin. Now, I believe that this is a final pre-trial. The case is set for trial on December the 13th. So is discovery complete?
It is from the state. Yes, Your Honor.
Okay. And there are no pre-trial motions?
Actually, Your Honor, when I was meeting with Kayla this morning, she advised me that she would be getting another attorney.
Okay. Are you going to hire your own attorney, Ms. Valentine?
I was wanting to do another plan attorney.
Well, that doesn't work that way. If you want another attorney, you're free to hire one. But unless there's a good reason under the law, and there seldom is, other than a conflict of interest, for me to replace Ms. Witt, I'm not going to do that. So if you want another attorney, you'll have to pay for one.
Then yes, I will. I've been looking actually today for it.
Okay, well, you waited quite a while to do that. That's December 13th, your trial date. In this case, it's already been continued, I believe, once, from I think September, if I'm not mistaken, to,
Actually, she failed to appear. She's been gone for a year.
yes, I know that, yeah. On the first case. So, we're gonna leave things on for right now. There's a trial date set, and, there is a rule 14 days prior to trial for any kind of a plea agreement, if there is going to be one. So, you'll need to, make that decision. Have, you discussed the written plea offer with the defendant, Ms. Witt?
Yes, I have.
All right, did you go over that with her, Ms. Valentine?
Yes.
And you're not in agreement with it, is that correct?
No.
All right, I don't know what it is, I just want it on record. So you're fully aware of what it is, and you're rejecting the offer?
Yes.
Okay, that's fine, all right.
Ms. Witt, when did you file your discovery? Actually, I did not file it. We don't have any additional discovery. We don't file that compliance statement.
Okay. All right. Ms. Valentine, I have a fax here from the probation department indicated that you have you failed to show for your reporting time on the 5th. That would have been last Tuesday. Have you reported there today?
I did not supposed to report on Tuesday.
Well, I doubt that that's, correct. Mr. Arjima, is on the call. Mr. Arjima, has she reported lately? You need to unmute.
Yes, she has.
When did she report?
She hasn't been contacted.
Okay, because this was dated on the 9th. All right. Now, also, I see a number. I'm sorry, go ahead. Okay. Well, I was just going to say, I have here some results showing positive drug tests, and one of them was contested and denied, so it was sent to lab and came back confirmed. So it indicated you were going to be assessed by Fayette County Recovery, but they didn't have to prove that because under the bond conditions, they feel that you should be evaluated. You're supposed to be evaluated and assessed, and if there's any treatment, you're to enroll in that and follow that. So are you being assessed? Have you been assessed? Okay.
My assessment is actually the night. I went at the night, and then she changed it Thursday. So it's just really for the night. So my assessment is tomorrow because my medication.
All right, will you make sure that you sign a release information to give to them to send to Ms. Arjina and the probation department so they are aware that you're complying with your bond conditions, all right?
Okay.
All right, so what we're going to do is we're going to set this for a status conference then to see where you stand on the new attorney. Let's see, this is December 13th, I believe you said the trial date is.
Yes.
So, looking at the 29th and the 30th, I think, check my calendar here. We get to 14 days. November 29th and 30th for the status conference. Pardon? All right. Okay. About, are you available at 9 o'clock on the 29th this week?
I am not, I'm scheduled with Fayette County.
Okay, what about in the afternoon?
I'm available after.
All right, well, I'm gonna kind of do that. All right, let's do 2:30.
Okay.
So 2:30, we'll do that by Zoom. So we'll need to know what your situation is with your attorney at that time. I don't know, you haven't talked to any attorneys yet, I assume?
I've been phone calls.
Yeah, okay. Well, I don't know what you expect to pay, but usually it's more, the retainer is a lot more than what people think. But that'll be up to you to take care of that, so we'll know by then whether you're gonna have another attorney or not. If you get another attorney, make sure they enter an appearance in this case as quickly as possible so that we can have and they should be prepared to be here at the status conference. So I'll give you, a little over 2 weeks to get that taken care of. All right. Anything further, counsel?
Yes. Is it the court's intention to try the 20 case first?
I think we'll try both of them together. That would be my intention. It's failure to fear to be tried with the underlying case. If it's related to the underlying case, in fact, you get a jury instruction that it's evidence of guilt in the other case.
Yeah, I would agree. I just assumed that the defense would be filing a motion that separate, but.
Well, if they do, I'll take a look at it, but, unless there's some involvement, or circumstances suggest that they can't be tried together, they'll be tried together.
Just want to make sure we got some feedback out.
Yeah. All right, anything else, Ms. Selwood?
Yeah.
All right. Make sure you stay in touch with probation, and we'll send you a notice for your next hearing. Thank you.
Okay.
You go ahead and sign off, Miss Valentine. All right, State of Ohio versus Brian Clemens. Okay, this is case number 21 CR 134, State of Ohio versus Brian Clemens II. And you're Brian Clemens II, appearing there on the screen with the name Brian Clemens in the corner. All right, and I believe Ms. Panzica is your attorney, and she's this hearing being conducted by Zoom. She's appearing from her office, and appearing on behalf of the state from her office is the prosecutor Collins. Defendant is charged along with Caitlin Owens with 2 counts of aggravated trafficking in methamphetamine, 2 counts of aggravated possession, and a forfeiture. This is the final pre-trial, and I believe this trial may be set for the 13th, actually December 20th. Okay. Now, I see the state's complied with discovery. As the defendant complied with discovery?
Your Honor, not just yet. I was going to go ahead and file a formal discovery. We don't anticipate any additional witnesses, documents, anything like that, but I will file up until about last night. We were hoping to work out a resolution. We've been in contact with Mr. King with the prosecutor's office. Doesn't sound like a resolution that we had, so Mr. Cummins and his owners just made a decision last night that they would do it.
All right. Well, I believe I indicated previously the final pre-trial is date is due for discovery and motion. So we'll get that filed by tomorrow. And then, Mr. Clemens, you are aware of the written plea offer from the state?
Yes, sir.
And you discussed that with your attorney, and you decided to reject that. Is that correct? All right. The rule of the court is that there is no plea bargaining after 14 days prior to trial. So your trial set for the 20th. So the deadline, if there's going to be a resolution, is December the 6th. Because after that, we send out notices for jurors, and jurors make changes in their routines, and we get calls about that, and it's very hectic, and particularly this being the holiday season. So once we send them out, there will be a trial. The only other option is that the state decides to dismiss the case in full, or you decide to plead and everything. Those are the options. There's no plea bargaining after the 14 days are set. So then we're planning, everybody's geared up for trial. I'm preparing jury instructions and everything will be ready to go. So if there's any resolution case, that's your deadline. All right. Anything further?
No, Your Honor.
All right, State versus Caitlin Owens. All right, this is case number 21 CR 135, State of Ohio versus Caitlin R. Owens. You are Caitlin R. Owens, appearing there on the screen on the mark, Caitlin Owens.
Yes, sir.
All right, this hearing being conducted by Zoom. The defendant is present. Also appearing on behalf of his attorney, Adam Blau. Is that you, sir?
Here, sir.
All right. On Ms. Panzica's screen. And also appearing for the state, the prosecuting attorney Collins. The defendant is charged with 2 counts of aggravated trafficking of methamphetamine, 2 counts of aggravated possession of methamphetamine, and a forfeiture. This is the final pre-trial, and the trial is set for December 20, along with co-defendant Brian Clemens II. All right, now I don't see any discovery from you, Mr. Blau. Have you provided that yet?
It's the same thing, Chelsea. You got to represent it in the commission's form.
All right. And there's no other pre-trial motions, correct?
Don't believe so.
All right. And Ms. Owens, you are aware of the written offer the state provided to your attorney and what it is,
Yes, Your Honor.
and you decided to reject that?
Yes, Your Honor.
All right. And I know you're on the last call, so I'll tell you and your attorney the same thing I told them, and that is the standing policy of this court, 13 years, is that there's no plea bargaining 14 days, after the 14 days prior to trial, that's the deadline, because again, we send out jury notices, jurors start making changes in their lives, they call in here, we have to make plans for that, write jury instructions. So if you decide you want to resolve this case, it has to be by December 12th or 6th. After that, the only options are a trial, state dismisses everything, or the defendant pleads guilty to everything. Those are the only options. So that's the standard policy. All right, now, anything further, counsel?
Hey,
Can I ask in a second, Chelsea, real quick, Judge?
Sure. Thank you. Good, sign off then.
Yep.
Okay, I think that 2 o'clock is open jail. That changes this clock here. 176, State of Ohio versus Carissa Frankie Del Purcell. Are you, Carissa Frankie Del Purcell, appearing here in the jail? All right. This hearing is being conducted by Zoom. Ms. Purcell's appearing from the jail. Her attorney is Daniel Witt, appearing from her office, and prosecuting attorney Collins appearing from her office. No, Ms. Witt, you and your client both in agreement that this hearing can be conducted by Zoom rather than in person appearing before the court.
Yes, Your Honor.
You're okay with that as well, Ms. Purcell?
Yes, Your Honor.
All right. Now, Ms. Purcell, since you're not in court with your attorney, if you at any time need to talk with her about anything or ask her any questions, you just tell me, and I can put the two of you into a breakout room where it'll be just the two of you talking with each other, and no one else will be able to hear you or see you, and it won't be recorded. Okay? All right. Ms. Purcell is charged with aggravated possession of methamphetamine and fifth-degree felony. Matter is set for trial, I believe, later. Yeah, December 13th. Ms. Purcell, I've been presented with a plea of guilty form, which indicates you're going to withdraw your not guilty plea, plead guilty to the charge. This is the front of that 3-page document. You see your name there and case number and plea of guilty form.
Yes, Your Honor.
And you recognize that document then?
Yes, Your Honor.
All right, on page 3, there are signature lines. And about a third of the way down, there's a sentence that reads, I enter this plea voluntarily. Immediately below that, there's a signature of defendant line. And I'll hold that up to the camera. And is that your signature there next to my index finger?
Yes, Your Honor.
When did you sign this document, Ms. Purcell?
Yesterday morning.
Right, and
Okay.
right, and Ms. Witt was there at the jail with you when you signed it?
Yes, Your Honor.
Did she go over with you and explain it to you and answer any questions you had?
Yes, Your Honor.
Did you understand that it was an agreement to plead guilty, which means there won't be a trial, the next step in your case will be a sentencing hearing?
Yes, Your Honor.
And have you had enough time to fully consider this matter before making this decision?
Yes, Your Honor.
And did you enter into this agreement voluntarily?
Yes, Your Honor.
Now, the agreement states on page 1, you're going to withdraw your not guilty plea, plead guilty to the charge of aggravated possession of methamphetamine under 2925.11 of the Higher Code, a fifth-degree felony. For the states, that you understand the maximum penalty for that could be 12 months in prison. If a prison term is imposed, the minimum could be 6 months, and any number in between. There could be a fine available of up to $2,500 and a possible license suspension of 6 months to 5 years. Do you understand that?
Yes, Your Honor.
Are you facing any felony charges in any other jurisdiction?
No, Your Honor.
Are you currently on probation, community control, parole, or post-release control for a felony?
No, Your Honor.
Now, under the law, if you are convicted of this offense and sentenced to a prison term, once you complete that term, under Ohio law, it is possible that the adult parole authority may, at their option, put you under what's called post-release control for a period of up to 2 years. What that means is that you would be supervised by a parole officer on the term set by the parole authority because the judge has nothing to do with that. And if they decide to do it, again, it's optional, but if they decide to do it and you violate any of those conditions while you're under their supervision, then they can return you to prison even though you served the entire term as ordered by the court for an additional period of up to, in this case, half of whatever prison term is imposed for one or more violations. However, if you commit a new felony while under post-release control and supervision, then an additional letter will sentence the judge of the new felony case to be closed. The judge would also be authorized to sentence you for committing that offense while under post-release control in this case to an additional period of 1 year, or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively the sentence in the new case. You understand that?
Yes, Your Honor.
Now, under the law, if I'm required to sentence you to prison for this offense, I can impose what's called community control, or what most people know to be probation. That means you'll be supervised by a probation officer under terms set by the court for up to 5 years. If during that period of time that you're being supervised, the department that felt that you were not complying, they would file a written notice of that to the court, serve a copy on you, then you would be entitled to have a hearing and be represented by an attorney. If the outcome of that hearing was that you had failed to comply, then at that time the court would revoke your community control, then sentence you to prison for 12 months and fine you $2,500. The charge in this case alleges that on or about March 27, 2021, Huntington County, Ohio, you did knowingly possess, obtain, possess, or use a Schedule II controlled substance with methamphetamine. Now, do you understand what it is you were charged with in that indictment, what the state says you did, when, where, and how they allege you did it?
Yes, Your Honor.
And have you discussed the charge in the case, the evidence in the case, possible legal issues in the case, possible outcomes of a trial with your attorney?
Yes, Your Honor.
Are you satisfied with their advice and confidence in this matter?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Are you taking any prescription drugs?
Prozac.
All right, does that interfere with your ability to understand what's going on or to talk and communicate in any way?
No, Your Honor.
Hey Ben, text Catherine and tell her we should be ready for her turn. In 5 minutes.
Okay.
All right, now, have any threats been made against you to plead guilty here today?
No, Your Honor.
Now, on page 2, there are a couple of lines that are printed in bold and underlined, so I'll read those to you. Defendant shall enter plea of guilty to the indictment, state and defense jointly recommend community control, and if defendant refers to drug court. Is that your understanding of the agreement?
Yes, Your Honor.
Does anyone promise you anything other than that gets you to plead guilty here today?
No, Your Honor.
Right now, the recommendation as to sentencing is not binding on the court. And so, even though the state and you are both saying you should get community control or probation, once I've heard all the information presented to me, I'm not required to give that sentence. I could decide that you should be sentenced to a term of imprisonment of between 6 and 12 months, fine, and $2,500, and have your license suspended for 26 months to 5 years. You understand that,
Yes, sir.
right? Now, do you hold any license or certificate from any state governmental agency, any occupation or profession?
No, Your Honor.
All right, you have certain rights you must understand before I can accept the plea from you. First of all, you have a right to have an attorney. Ms. Witt was appointed to represent you. Now, her appointment isn't simply to work the case out, but provide any defense that could be available to you under the law that you wish her to provide. So, if you decide you do not want to do this, you'll still be represented by Ms. Witt. She'll defend you throughout the case, including a trial, if that's what you want. You understand that?
Yes.
Right now, the Constitution, you have a right to have a jury trial, in which 12 people will be selected from a group of citizens that live in Huntington County that will be summoned to be on jury duty on your trial day. After 12 of those people are selected, the evidence will be presented, they'll be instructed on the law, and then they will decide by unanimous verdict, meaning all 12 of them will have to agree, as to whether or not the state proved you guilty or proved guilty of that. Now, if you did not want to have a jury trial, if you did not want to plead guilty, you can waive, which means give up in writing your right to have a jury trial, and in that case, you have to hold a court or bench trial. That means that instead of a jury hearing the evidence, the judge will be the one to hear the evidence, apply the law, and decide whether or not the state proves you guilty or proved guilty of that. You understand that? Right, under the Constitution, you have a right to confront witnesses against you and to cross-examine through your attorney in open court. What that means is that witnesses against you have to come in and testify in this courtroom in front of you and your attorney and anyone else that's present. After the prosecutor's done asking the witness questions, your attorney can ask questions. That's called cross-examination. And the purpose of that is to bring out evidence that helps your side of the case. You understand that?
Yes, sir.
Under the Constitution, Mr. Purcell, you have the right to use the power of this court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're not certain are going to commit voluntarily, it's your request court issues a court order, that's a subpoena, and that forces those witnesses to come to court to be able to testify if you want them to, even though they don't want to be here. This is the same way the state's witnesses are required to come to court to testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, Mr. Purcell, you have the privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. So no one can ever make you testify. Prosecutor can't, the judge can't, you make the decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person, and no one's even allowed to comment about it, except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, under the Constitution, Ms. Purcell, you are presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged in the indictment. So what that means is that the burden of proof isn't on you to prove you're not guilty. The burden of proof is upon the state to prove that you are. And in fact, you don't even have to present any evidence at trial. You can, but you're not required. Whether you present any evidence in your own defense or not, the burden of proof will remain upon the state of Ohio to prove your guilt on every essential element of the defense charge and proof beyond reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that? Now, you originally entered a plea of not guilty. Not guilty plea denied the allegations, denied you committed any crime, and that plea exercised or revoked the rights I just described for you. If you change your plea today from not guilty to guilty, that is the complete opposite of not guilty plea. The guilty plea admits the allegations in the indictment, admits that they're a crime, that you committed that crime. And that plea waives or gives up all of the rights that I just described for you, except your right to have an attorney. You always have a right to have an attorney no matter what you plead. With that exception, your plea of guilty waives gives up the right to have a jury or court trial, waives gives up the right to confront witnesses against you to cross-examine through your attorney, waives gives up the right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, same as the state, waives gives up your privilege against self-incrimination because that's what's used to find you guilty, and waives gives up your right to require the state to prove your guilt, proof beyond reasonable doubt, because if you say you're guilty, the state's not required to prove your guilt. It also subjects you to immediately being sentenced if the court decides to do that, and it waives gives up any right to file an appeal of any rights you think may have been violated up until this point in the case. Now, by sentencing the maximum sentence under the certain circumstances, you can file an appeal that would have to be filed within 30 days of your sentencing entry filed. You understand all of that? We've been my mistake. Text her back and tell her disregard. I forgot we continued that.
Yeah.
Because she's not had time to get her to go. Alright. Now, are you a U.S. citizen?
Yes, sir.
Do you have any questions, Ms. Purcell, about the charge or the possible penalties?
Yes, sir.
Do you understand?
Yes, sir.
Have any questions about the plea agreement?
Yeah, there was a talk of the future, I did have questions for us, I didn't want to get started right away, and you and I didn't get that. So,
Well, I can't tell you anything about that. That's not part of the agreement. That has happened. And if it's something that happened before you were put in drug court, then it wouldn't be a violation of your community control. If you plead guilty to this charge, it's only a violation of community control if you get a charge that occurred once you were on community control. But if there's something you're indicted for that occurred before today, or before you're put on community control, it would not be a violation. You'd still have to face that and have to be a judgment of what happens. But, that's something that will remain in the future.
okay,
Does that answer your question? Do you need to talk to your attorney about that at all?
yeah.
Okay.
Thank you.
Well, I'm glad you brought that up. One of the other things is drug court is not something that I order people into. You have to apply for it. I see you have filled out an application and talk to Ms. Sturgeon. I'll make a decision once I review it, if it meets criteria and if it's clear that this is something you're serious about, because drug court is for people that are focused on being sober, because sobriety will usually maintain that they don't get into more trouble. Whereas regular community control is just to try to stay out of prison, and some people, do okay at it, and other people don't think it's a big deal, and they don't do okay. So you have to ask the drug court. I don't force you into it, but make that decision. Just because it's recommended doesn't mean it'll be granted, because I'll make the final decision as to who gets in, understand? Okay. All right, anything else, any other questions you had about that? Yeah, okay. You have any questions about the constitutional rights I display? You understand those? You have any questions about the plea of guilty, what it means, what the consequences of that will be if you enter here today?
Yes.
Well, do you have any questions first?
Oh, no, you're sorry.
Now do you understand?
Yeah.
Okay. All right, now, is there anything else you'd like to speak to your attorney about before we go any further?
No,
You have any other questions about anything I've explained to you here today?
that's all.
Right? Then it's your decision to withdraw your non-guilty plea and plead guilty to the charge pursuant to the terms of this written plea agreement that we just got over.
Yes,
And as to the charge, there's alleges that on or about March 27, 2021, in Hyde County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine, violation of Section 2925.11 of the Ohio Revised Code, a fifth-degree felony, carrying a possible term of imprisonment of between 6 and 12 months, fine of up to $2,500, and a possible license suspension of between 6 months and 5 years. How do you plead?
that's all.
All right, the court finds on this day, in open court, the defendant was advised of all of her constitutional rights, and made a knowing and intelligent voluntary waiver of the same, so as per Rule 11. Please accept it or file. Defendant is found guilty of the charge as set forth in the indictment. The court will order a pre-sentence investigation that will include an assessment for substance use disorder and or mental health, and cases referred to the drug court docket. I don't think I have a letter from you yet, this first one. Okay. We will set the sentencing. December the 15th at 2 p.m. Now, you're on OR bond in this case, aren't you?
Yes, sir.
What are you being held in jail for?
This is mere time for the judgments for time for my outdates, so,
November?
yes, sir.
Okay. Alright. Well, if you are released from jail, sounds like you will be, then make sure you get in touch with your attorney, get in touch with the probation department, and we'll also probably do your sentencing by Zoom, but we'll make sure you give the probation department an email address, a good email address, and so forth. Are you trying to get her into a treatment program, Ms. Sturgill?
Yes, sir, we have been discussing it.
Okay, well, if that occurs, you'll, of course, she's okay to go for this work, but you'll have to get that resolved with Judge Jenkins' case. Okay, anything further from counsel?
There.
All right. Ms. Collins, did you get the notice of the continuous entering case?
Yeah.
Yeah. She apparently, I know, now that's not surprising. She's in Urbana and apparently told Miss Hatter she can't get, even if she had Okay, you need to unmute there, Mr. Spivey? Down left-hand corner? There you go. Can you hear me okay? Yes. Okay, this is case number 21-0157, State of Ohio versus Corey Spivey. This hearing is being conducted by Zoom. Spivey's attorney is Danielle Witt, appearing by Zoom, and the prosecutor is also appearing by Zoom, Ms. Collins. The defendant is charged with one count of aggravated possession of methamphetamine and fifth-degree felony. This is the first pretrial. Final pretrial set for December 15, and the trial date is set for January 11. Now, see, the state provided a bill of particulars and discovery, and have you filed your yes with? All right, well, that'll be due by the final pretrial. Do you anticipate any pretrial motions?
None that I'm aware
All right. Has there been a written plea offer provided?
Yes, Your Honor, I have that.
Do you have that, Ms. Witt?
of. I do.
Is your client aware of that?
Not yet, I'm able to speak to you.
Okay. All right, well, when we hang, what I can do here, put you to the breakout room before, we're gonna talk about it before we're done, or after we're done here.
Okay.
All right. All right, are there any other matters that come before the court at this point?
No, Your Honor.
Okay, where are you now, Mr. Spivey? Okay. All right. Yeah, I'm familiar. All right, I'll put you and Ms. Witt into a breakout room so the two of you can talk. Ms. Paul, you go ahead and sign off. And then when you're done, just then leave the breakout session, and we won't be able to hear you.